Here is what we're discussing this morning, and this is what I'd like us to get into at this point. We're re-examining the African Court of Justice, the fight for human rights, and the quest for self-determination. Or is it, quote, self-immunity? And interrogating this issue, I have some experts in the studio. We have Dr. Evelyn Asala, Lecturer, Faculty of Law, University of Nairobi, and Annette Nerima, Program Manager, Kenya Human Rights Commission. So what is the background to this discussion we're having this morning? There was a meeting that was held of UN leaders in the country a couple of some weeks back, at which Kenya signed a certain protocol. And we were told it was the Malabo Protocol. There was some concern that had to do with the African Court of Justice and Human Rights. Now, this is something that was adopted in 2014 in Equatorial Guinea. In case you're wondering where the Malabo comes from, it's a place in Equatorial Guinea. But the president later, rather the Foreign Affairs Ministry later clarified that what was actually signed had to do with the Pan-African Parliament. But why is this issue of the African Court of Justice a sticky issue, a contentious issue? Annette, I could start with you because, as I mentioned, the Kenya Human Rights Commission, Muhuri, issued a statement raising concern that if indeed Kenya had signed, or rather President William Ruto had signed this protocol, then there were serious issues, one of which you raised was the question of immunity of senior officials.
Okay, so thank you so much for having me this morning. And the reason as to why we raise concern is because of the contentious article, that is Article 46A in the Constitutive Act of the EU. And so dating back on the history and evolution of and getting us to the level where we now have the African Court of Justice and Human Rights, we first started by having the African Court of People, of Human and People's Rights. And then also there was the African Court of Justice of the AU. So these were collapsed in the year 2005 to now bring us to the level where we are advocating, or we were journeying towards ensuring that in the African continent we now then have the African Court of Justice and Human Rights. So getting to that level, we saw very many African countries are signing and then thereafter ratifying to the same. But then we have now gotten to a level where we have the evolution, and many countries, after signing to the African Court on Justice and Human Rights, there was then the amendment to the same, to the Act, and the amendment was then titled as Protocol on the Amendment to the Protocol on the Statute of the African Court of Justice and Human Rights. And so with this amendment then, we had the Article 46A, which again I would just read verbatim on what it states. It states that no charges shall be commenced or continued before the court against any serving AU head of state or government or anybody acting or entitled to act to such capacity or other senior state officials based on their functions during their tenure of office. So definitely what this means is that it's providing immunity to heads of states, the EU heads of state, from being investigated and even prosecuted should they be found culpable of very many crimes that have been listed in this act. We have 14 of them, and some of them are crimes against humanity, the war crimes, piracy, corruption, money laundering, among others. So should any head of state and senior government officials be able to commit these crimes while they are serving in their respective government, then they are not going to be held liable, they'll not be investigated, and no charges will commence until that point when they are out of office. So we raise a concern because, again, as justice crusaders, as champions of integrity, good governance, rule of law, you know, and also looking at the steps that we've made on the continent as regards democracy, I think this is a drawback You know, this is a drawback, and we raise concern because, again, why would heads of state rush to be able to sign and also ratify to this kind of law? For me, it's wrong, and it also portrays ill intention. Because at the end of the day, if at all somebody has committed a crime, and within this particular framework, it was clear they committed that they'll be able to ensure that at the end of the day, the rule of law prevails. They'll ensure that they commit to fighting all those crimes that have been listed in this particular act, and also just ensuring that there's also accountability. Fighting of impunity was actually one of the commitments by the heads of state. How does it turn again that they are again ratifying to a law that will provide them, safeguard them or protect them from facing the law should they commit crime? And again, for me, that definitely points to the fact that on the continent we then have leaders who are self-centered, leaders who are not pro-people, considering, again, as I've said, the gains that we have made on this continent. That would be really, really wrong. It's a setback, and it's the reason as to why, as Kenya Human Rights Commission and Muhuri, we came out to condemn this strongly through our statement.
All right. So it hasn't been signed yet, according to the Ministry of Foreign Affairs. But again, what we're discussing is why is this such a sticky issue? Perhaps, Daktari, you could help us give some context in terms of the background of what triggered these amendments. I recall it was around 2014. So if my memory serves me right, it was when the president, then Uhuru Kenyatta and William Ruto, were facing charges at the ICC. At the time, there was a sentiment that those primarily targeted were from the continent. And so there was a clamor that, you know, this is clearly discrimination. Do I have are my recollections correct?
Thank you very much, Olive. Actually, you're right. This amendment was introduced in the context of prosecuting the head of state of Kenya and the deputy. When you look at the AU summit decision of October 2014, we understand the context within which this particular amendment was introduced, and it's actually with respect to the Kenyan cases that triggered this amendment to the protocol. And so I appreciate and I agree with my colleague that immunity in international criminal law is a sticky issue, and it is not an issue that you know, it comes and goes so easily. And one of the main reasons is because it creates the impression, the wrong impression, that there is an embrace of impunity. Yeah, and I know the amendment sends the wrong signal that a continent that prides itself to be fighting impunity is adopting this kind of amendment, which creates the perception also that its leaders are embracing impunity. But again, aside from the motive behind the adoption of the amendment, I would like to look at or question the fact as to whether this amendment is merited in law. Yeah. And when you look at the merit of it, and by listening to my colleague and also having read their statement, I get the impression that, you know, they have two main arguments that, you know, this particular amendment is a contravention of international law, and it also undermines the International Criminal Court. And so with respect to international law, we, from the history of international criminal justice system, we see that we do not have a law that excludes the prosecution, that excludes the immunity, yeah, for international crimes in international tribunal. Of course, we do have, and the ICJ has made this clear, that there is, and based on the concept of sovereign equality of states, there is immunity for heads of state and foreign affairs ministers and, you know, heads of governments in foreign jurisdictions, but not in international tribunals. And so when we talk of international tribunals and the aspect of immunity, we find that we do not have a law that guides this. Yes, we see in the ad hoc tribunals of Rwanda, Yugoslavia, Sierra Leone, there is an express clause that excludes application of immunity. But this does not mean that exclusion of immunity for international crimes has become a custom of international law. For it to become a custom, we need to see consistent state practice and also the feeling of obligation by states to adopt this kind of thing. But this does not exist. The practice in ad hoc jurisdictions are not states per se. And so we cannot say that we have state practice in these aspects. And therefore, we cannot say that we have an evolving custom of international law as such. And so I would be reluctant to say that we have an international law that excludes immunities for international crimes in international tribunals. And when you look at the argument of the ICC aspect of it and undermining the fact that the ICC is a court, a supranational court that excludes immunities, this also just speaks to the fact that the African court is an independent court, subject to its own jurisdiction. And this does not even bar prosecution. It's not true that, you know, when a country accedes to the Malabo Protocol, then it's excluded from prosecution. It can as well be prosecuted before the International Criminal Court. And so for me, I would be least worried that we are embracing impunity, especially for countries that are parties to the Rome Statute. In fact, for me, I would look at the Malabo Protocol as trying to expand or narrow the impunity gap, in the sense that only 33 states in Africa are member states of the Rome Statute. What about the other 22 states? It means if these 22 states become parties to the Malabo Protocol, at least we have a supranational mechanism of reaching out and narrowing impunity in these countries. So when you look at it broadly, then you see that there are other positives in the Malabo Protocol that we should not shun and discourage states from acceding to or ratifying. And so I would encourage states to ratify the Malabo Protocol, and if need be, then they can do the necessary amendments later. But for me, I don't see any embrace of impunity and no violation of rights per se.
All right, so we need to take a break, but we'll come back with more detail, because it's not just a question of immunity that's contentious. It's the definition of the crimes. What was one of them was something a government. I will pull it up, okay? We will refer. And there was also a question of funding. Already the African Union is struggling to fund its affairs. How then would it fund this court? And because funding, the Kenyan judiciary has said, is critical to the dispensation of justice. We take a look at all of that on the other side of this break.
Mama Stevo, where are the kids?
I think they're upstairs doing their revision.
Oh, you guys are here. Maria and Steve, which revision papers are you doing today?
Baba, mimi nashughulikia maswali ya marudio ya somo la Kiswahili kutoka kwa gazeti la Taifa leo.
Na wewe?
I am working on the mathematics revision paper from the Junior Sport magazine of the Daily Nation.
Wow, this is wonderful. Are the revision papers from Taifa Leo and Daily Nation working for you guys?
Yes, Dad. Wanauliza maswali yao kwa njia nzuri na nyepesi sana.
And the questions are in tandem with our syllabus.
Dear parents, invest in Taifa Leo and Junior Sport for KCPE and KCSE revision papers. Kwa maswali ya gazeti la Taifa Leo, usiukose uhondo huo kila Jumatatu hadi Jumamosi. In our Junior Sport, it's every Monday. Do not miss out.
Mosacha hizo.
Wewe nani?
Unajua deal na mimi.
You're treading on dangerous ground.
Nakuuliza unawajua? Kevo bana, pole pole, jo ni dem. Udem anajua kitu.
Mzee mlango ndio hii.
Mbeni kilo 2.
Ni jina gani?
Oya tije. Mabubu fire huku nje tuende.
Time to step out, get down and jam down. Right into reggae, raga, roots, and everything that makes you say wagwan. They talk about radio silence. We don't know what that's about. We jam up the volume and the vibes on your radio on 96.3 Nation FM. We take a ride to the hood, Jumtani, ndio mambo iko na design ya kivyake. Jam Down mtaani, tunaingia mtaa wako na tunaguziana na watu wetu. Kiroma ni muhimu, na pia ni muhimu kujiupdate na nini kina trend kwa zone ya reggae. Hapa ni Jam Down vibes. We jam down way past when the sun goes down, and that's how it goes down. Jam Down style on 96.3 Nation every Saturday from 7 p.m. to 10 p.m. Then at 10 p.m. on NTV.
Misha!
What? Why don't you go and help Adita?
What's wrong? Tell me.
It's none of your business.
I'm your doctor. I was the one who operated on you.
And I'm sure that they're gonna kill the both of us. Call the police right now.
I thought you were a decent man. That you saved so many lives. I can't believe it. I can't believe it.
To protect our family from germs that cause illness when it's cold, we use Dettol soap.
Dettol soap with germ defense gives you protection. When it's cold, germs are transferred in different ways, and Dettol soap's germ defense protects you from up to 100 illness-causing germs. Be Dettol sure.
On my dark marks, I've tried everything from A to Z, even vitamin C, but hardly any results. Nivea Lumina 630 works from day one, with visible results in just 2 weeks, and 71% dark marks reduction in 12. Join the 1 million women already using the #1 Lumina 630 from Nivea.
Do not hold back in any situation. Eno gets to work on the 6 symptoms of heartburn fast.
You do know you said all of that out loud, right?
If symptoms persist, seek medical advice.
Thank you for staying with us on AM Live. And I've been asked, what is this Malabo protocol? Well, Malabo is a capital of Equatorial Guinea, and why this conversation is relevant today is because, among other things, we had the protests over the Finance Act. There were accusations of police excesses. The ICC was invoked. The other day, their prosecutor was here, and that is Karim Khan. And when the nation followed up with him as regards accusations, or rather the sentiment from Azimio that it called the impartiality of the court in question, he recused himself, according to a statement sent to the nation from the, quote, Kenyan cases. So now we're having this conversation around, because it's, they say, everything everything comes full circle. So we are back again at the Africa Court of Justice, what its intention was, what are the sticky issues around it, and varied opinion already we have gotten from our panelists. But what triggered this conversation was this report that was published on the Standard, and this was on the 8th of August. Ruto signs Act that established African Court of Justice. This is the statute that establishes the African Court of Justice and Human Rights, an organ of the African Union. The AU adopted the Malabo Protocol in 2014 with the aim of introducing a regional accountability mechanism and reinforcing the concept of African solutions for African problems. Now, on the same day, there was a statement that was released by the Kenya Human Rights Commission and Muhuri that if indeed that was signed, then it presented a challenge. And their issue is this: Ruto on path to grant self-immunity for international crimes. And NET has already referenced the article in question on immunity, Article 46A. And international crime victims could suffer as the protocol shielding Ruto from such charges, while his president is poised to take effect as early as October 2023 if it had been signed, which the Ministry of Foreign Affairs said it was not. And here is the PS for Foreign Affairs, Korir Singoe. He says false. Kenya signed protocol to the Constitutive Act of the African Union on the Pan-African Parliament on July 16th, 2023. The protocol establishes the Pan-African Parliament. Kenya has not signed the protocol to the African Court of Justice as alleged, and and I'll pull up those images. At the time, Kenya was hosting African Union leaders. Does this net assuage any fears that you had in this respect? The fact that the Foreign Affairs Principal Secretary has come out to clearly state that no, this is not the protocol that was signed.
Great, and I think if it's not the case, I think it's a good move, the act that he actually indicates that was signed, because again it promotes gender balance, in terms of representation of women. So that's a good thing. But I think back to the topic of the day, the fact is, as Kenya in 2015, we already signed to the Malabo Protocol. What was remaining was the ratification. And so with the looming deadline of October 2023, the next thing, when you look at the process and the series of us getting to a level where we can now say we are bound by this treaty, the next stage would then be ratification. So what, considering that we already signed this in 2015 during the Jubilee administration, which again we can say this was a government that was, the current president was the deputy president at that particular point in time. And so the next stage in terms of processing, once you have done the signing, you then go to the next stage, which is ratification. It may not have happened on the particular date as he says, but the fact remains that Kenya would then be ratifying to this treaty. So much as the details might not be clear as it's being stated, and also the date. And for us, in our statement, we had indicated that this happened on the 24th of July. The date that has been provided by the PS there is that of 16th, which also varies and states some otherwise. But based on the information that is available, this protocol was signed to. So as I'm saying, in 2015, it was signed, so we are saying we are past that. What was left, what was the next step, was ratification. We may have ratified this because, again, looking at the deadline, the 23rd, the October deadline, that is the only next step that we are looking at. So without providing without having the evidence at hand, I think for me the most important thing is for Kenyans to be on the lookout that come October, will Kenya be listed as one of those countries that have ratified? In my view, I think that is going to be the case because, again, once you do the signing, what you are showing us, what we can only interpret it to be, is the intent that we really intend as a nation, that our leaders, our country, Kenya's leadership, intends to be able to join the other heads of state to ensure that they provide immunity to themselves. So we had already started a step, and I think towards ensuring that we ratify to this. So for me, I think the most important thing that we need to do as Kenyans is be on the lookout. Come October, will Kenyans be listed? And I think it's important that I also mention that when it comes to the amendment, the protocol amendment of the statute, of the protocol of statute to the African Court of Justice and Human Rights, Kenya was amongst the first 5 countries that ratified to this. So again, I think it's important that with these moves, the timeliness and being amongst the first countries, it tells a lot of our leadership. Yeah.
Okay. Daktari, my question would be this, right? My understanding of what you're saying about October is that there are set timelines within which the protocol would be signed, and then it would require to be ratified, I imagine, within a certain period. And I'm going to give the Ministry of Foreign Affairs the benefit of the doubt in this, for the purposes of this particular conversation. So even if we signed it in 2015, hasn't there been a time lapse? Have we gone back? Therefore, does it reverse issues back where we are back to the square one with regard to the ratification?
Thank you very much, Olive. I think what is coming out clearly is the clandestine nature of ratification, the ratification process in Kenya. which I find quite interesting because the governing law, which is the Ratification and Treaty Making Act, actually requires this to be a public exercise.
So I just want clarity on one issue before we get into, actually, that's one of the issues I wanted to talk about. Is there supposed to be public participation somewhere in all of this? But first, is essentially the signature that was appended in 2015, is it time-barred? No. Signing a statute does not mean that you must ratify within a specific time. There's no time limit. No, there's no time limit. And just when you sign to a treaty, it means you took part in the negotiation of the treaty. So if you have taken part in the negotiation of the treaty, then you agree that we are signing and we intend to, look forward towards ratifying the treaty and being bound by it. Okay, so why are we sorry, literally, this is an area I'm not too familiar with, but why are we looking at October if there are no set timelines?
Because it needs to come to effect.
Okay.
Eventually it needs to come to effect, and therefore it's time bound. There's that stretch, and so what we are seeing is a rush of heads of state to be able to...
Also, this is a time table that was set by who, the AU?
Yes, to enable now the kickstarting of this, what do you call it, the work of the African
Court of Justice and Human Rights. But also, quick question, doesn't there need to be, because I was reading up, and I'll pull up those documents, on this whole protocol on the Pan-African Parliament, right? And it said they would require a minimum number of countries to sign on. Is that the same case with this?
Yeah, actually the coming into force of a treaty is based on the number of ratification it has acquired. And of course, a treaty is free to provide the timeline, but again, it's always pegged on the number of ratification. So you find a treaty making provision to the fact that the moment this treaty acquires 15 ratifications, then it shall come into force. Yeah, and so once the ratifications have been acquired, then the treaty comes into force. What has been delaying the Malabo Protocol is that it has not so far received any ratification. And so we can't really tell whether it will ever come into force or not. Yeah.
Okay, now I get it.
Yeah.
Okay, so you were explaining.
Okay, so the ratification process in Kenya requires approval by the Cabinet and the National Assembly. And the approval by the Cabinet, once the approval is received from the Cabinet, then the CS has to move to the National Assembly. And the National Assembly process is not a one-day event. It's an elaborate event which requires the respective parliamentary committee to engage the public, to participate, to give their views, and so that by the time the National Assembly is considering the treaty and to whether it gives its approval or not, then it is also making reference to the outcome from the public. So it is really not a clandestine process that we seem not to be aware of what is happening. But again, you can't rule out the fact that most of these processes happen without the knowledge of the public.
Really? Annette?
Yes, I think I could just jump in and also point out that, again, looking at the African Court of Justice and Human Rights, it recognizes the national laws. And in this case, in Kenya, we have the Constitution. We have a very powerful article, that's Article 1, which states that sovereign power belongs to the people, and the fact that we also exercise this indirectly through our members of parliament. And so, as she has mentioned, looking at the process of ratifying to this treaty, after the cabinet secretary approvals and then the sharing of the same in the National Assembly, it's then the expectation of every Kenyan that public participation or engagement of critical stakeholders should be happening. But again, as she has also pointed out, it's important that this process, to note that this process are happening under wraps. Yeah, so it's very difficult for Kenyans to tell what is happening at the end of the day. What we see is that the end goal, the ratification and all this, and then we begin questioning and asking ourselves, where were the voices of the people? Where were the voices of critical stakeholders when all this was happening? Because I know for sure, again, if parliamentarians, if the National Assembly is working in the interest of all Kenyans, then for sure this is not one of the treaties that they would really push the Kenyan government to be able to ratify too. So again, I think with this move, all we can say that our parliamentarians and the leadership has really failed us as Kenyans, because again, I'm certain in this country, during the post-election violence, the 2007, 2008, we had victims from the protest. People were killed, people lost their lives, people lost property. Where are they today? Have they received justice or not? You want to tell me, if at all we were being very fair, if at all we were being impartial, is this a law that you would want to say as a government you would want to ratify too? Definitely not. So we are saying the voices of the people and critical stakeholders is missing, and that should not be the case. Because again, we have a really progressive constitution.
All right, and we are at the point as a country where we have the inspector, the Azimio, claiming that there were police killings, which has been backed by independent verification of IMLU, for instance, and Amnesty International as well, and IMLU, at least I've seen that they named the people, the type of injury that was sustained, and they also, and they put the figure at above 30 people. The figure given by Azimio is much higher. Again, we have to hold them accountable for those figures and where they obtained them. But then we also have an Inspector General of Police who has come in and said that bodies were hired. But I'm just pulling up images here of the president when he hosted leaders from the African Union, and he met several of them, and this was on July the 16th. And those he met when the said Malabo Protocol was said to have been signed included the president of the African Human Rights and People's Court. Almost there, it was around July the 16th. Let me just scroll up a little bit faster. So what is the present, and here we go. Just about, here we go. So the African Union, they tweeted, is working together in consolidating and strengthening its institutions so that they can serve the continent better. Kenya will play its role in strengthening AU institutions, including regional economic communities, the African Court on Human and People's Rights, and the Pan-African Parliament. So what is the present remit of this African Court on Human and People's Rights, Dr.?
Yeah, the African Court on Human and People's Rights was established under the African Charter, and the African Court of Justice was established under the Constitutive Act, or if you like, the Constitution of the AU. And so at some point, the AU felt it was undesirable, the cost implications, and therefore the need to merge the two courts into one. So then we have the protocol, the draft protocol on the African Court of Justice and Human Rights. And this protocol, just before, of course, it came into force, we see the amendment that introduced the international crimes and transnational crimes. And so this amendment,
as it stands, this court does not handle international crimes?
No, it deals with human rights issues.
Like what?
So, for example, the African Court will deal with human rights issues of, let's say, indigenous people who feel violated or something of the sort, or any group of people who feel that their rights, so long as a certain rights is of public interest, then you can take it to the African Court of Human Rights for determination, and again, then the court will try to make a follow-up and monitor its implementation with the relevant state.
Okay.
Yeah.
All right, so it does not presently deal with international crimes?
No.
Okay, so there were several issues we said which are sticky with regard to the African Court of Justice and Human Rights. And I just want to pull up assessment that was done by Amnesty International, which documented these issues. And here we go. Malabo Protocol, legal and institutional implications of the merged and expanded African courts. And so they begin with the issue of immunity. But this was as of 2017, 9 countries that have signed the Malabo Protocol as of May, they tell us 2017. Countries that have ratified the Malabo Protocol, 0. Let me just zoom in a little bit further so that we can get a better view of this. That should be much better. Here we go. So June 2014, the date of adoption of the Malabo Protocol by the African Union. Arusha, Tanzania is a proposed seat of the court. 15 African Union member states that need to deposit their instruments of ratification for Malabo Protocol to come into force. So that's what we've heard from Annette as well as Daktari here. So the question number one, the question of immunity, which has been very well prosecuted by Annette. No charges shall be commenced or continued before the court against any serving African Union head of state or government or anybody acting or entitled to act in such capacity or other senior state officials based on their functions during their tenure of office. And serving, so essentially this is the thrust of it. It's an immunity clause. It will have, the Amnesty International tells us, serious implications for the legitimacy and credibility of the court. Serving heads of state and government will be immune from investigation and prosecution. But isn't that the case already, even within Kenya's law, Annette, or is it a case where you cannot be prosecuted even for crimes that were committed when you were in office? What does the Kenyan law provide in this respect, at least where the president is concerned?
Yes, and I think just to take us back, you know, when we talk about the Malabo Protocol in itself, and also the fact that we now have the protocol stating that any sitting head of state will not, no charges will commence or investigation commence should they be implicated on crimes that are listed in this. I think for me, what then is of concern, because I've already talked about the immunity aspect, and also what remains as a gray area is the issue of the senior officers within the state. For me, that's ambiguity, especially in the law, because again, it leaves to the discretion of those in power to be able to make a determination on how they would want it to go, and also identify who constitutes a senior officer or high-ranking officials in the state. At this particular point, we'll have anybody, because now it's at the discretion of whoever is in authority to be able to determine that. We may now end up deepening the inequality, because it's going to turn us to the situation of the haves and have-nots to be able to determine who again faces the law. Because right now, when you talk about senior ranking officers, who are they? Are they the PSS? Are they the cabinet secretaries? Are they the members of parliament? You know, who is this? You know, so for me, that's an area, a gray area that can be exploited and be able to push us to very many retrogressive situations that we are past as a continent and also as a nation. So I think it would be unfortunate that the treaty kicks off without maybe amendment or clarification in terms of definition on who these people are. And I think also talking about the immunity aspect, and there's a good example to it. I mean, when the former president of Chad was being prosecuted in Senegal, it was expected that, and also there was a commitment by different AU government states, AU government members, to be able to channel resources, finance the prosecution, the process, you know. But unfortunately, they were not able to commit even their resources to enable this case to go on. What does that point to, you know? It points to the fact that if this trend continues, you know, what we are likely to see is a failure of the court at the end of the day on the continent. Yeah, for in my view, I would say not really lack of resources, but lack of commitment and support in the fight against crimes of the heads of state. It also will then be raising us or pushing us to the understanding that with the rising authoritarian states at this particular moment, we see very many states coming up, you know, that have that we can safely say that they are authoritarian. Even our country, Kenya, right now, I would say we are slowly sliding there, yeah, and very many African countries African countries. So this definitely is going to push us to a level where we will have a court on the continent, but a court that is unable to function, a court that is unable to meet its objective, because again, there is the impediment of not only financing, but also cooperation and commitment from the heads of states that have then ratified to this.
All right, I'm pulling up article, just Googled. Article 143 should be chapter 9 on the executive. Let me see here. Chapter 9, yes, the executive 143, protection from legal proceedings. Might take me a while to get there, but even as I do so, Daktari, doesn't Kenyan law already provide immunity for the president?
Yeah, the president enjoys immunity under the Constitution of Kenya, but there's an exception to it. The Constitution qualifies that where the country is party to a treaty that excludes immunity for international crimes, then the president will be prosecuted for those crimes. And so we get a qualification to the fact that even though the president enjoys immunity, it's not absolute, and it will not apply to international crimes where we have ratified the relevant treaty.
All right, so I just about there, and here we go. Protection from legal proceedings, Article 143 of the Constitution of Kenya. Criminal proceedings shall not be instituted or continued in any court against the president or a person performing the functions of that office during their tenure of office. Civil proceedings shall not be instituted in any court against the president or the person performing the functions of that office during their tenure in office in respect of anything done or not done in exercise of their powers under this constitution. Let us see. I found the portion you're making reference to, which is 143.4. The immunity of the president under this article shall not extend to a crime for which the president may be prosecuted under any treaty to which Kenya is party and which prohibits such immunity. In this case, this would be the Rome Statute, I imagine.
Yeah.
All right. Okay, so this is what Kenyan law provides. But, Dr. what do you make of Annette's argument that, you know, that, because I know you said this is a good thing, the African Court of Justice, because you talked about how many countries, 33 is it?
Yeah, 33
African
parties to the Rome Statute.
To this Rome Statute on the continent.
Yes.
And so there are 22 who are not captured.
Yeah.
And so you're saying that this would be a good accountability mechanism.
Exactly.
But what do you say of the argument Annette has that if indeed these people will enjoy immunity, the people described here in 46, and by the way, what does that BIS stand for? Stand for the 46B, and then there's a BIS somewhere. Let me just
there's
pull it up.
There's normally a 46, then that's another 46. This is an amendment to a 46 that already existed under the African protocol, the African Court of Justice.
Oh, so that's what it means. Okay, thank you for providing that insight. Because it says no charges shall be commenced or continued before the court against any serving African Union head of state or government or anybody acting or entitled to act in such capacity or other senior state officials, which is the part she's like, this is ambiguity, based on their functions during their tenure of office. Now, if there's no big brother, such as the ICC, keeping African leaders in check, does it not entrench immunity? Do you still hold your position that it's a good thing?
I'm not saying that clause is a very good thing, yeah? But what I'm saying is that it is something that we can do with. And we can look at the amendments. What should we amend? And it should not be the reason why we are throwing out the Malabo Protocol in totality. Because this is something, we can have the AU, you can talk to the AU to adopt the necessary amendments. I think one thing I find quite interesting is that when any argument originates from an African leader, then the world goes out rampant, saying that this is impunity, Africans are embracing impunity. And for me, this is not the kind of argument that is progressive in the fight of international crimes. I would rather we sit down with the AU officials and see, you know, let us reason together to see what we can, you know, how we can make the necessary amendments and have them adopted within the protocol, rather than just saying that let us ignore the Malabo Protocol in totality. Yet the Malabo Protocol is not all just about this immunity. It has very other good intentions. For instance, when you look at corporate accountability, you notice that even these African leaders will not be able to perpetrate these international crimes by themselves. They are facilitated from elsewhere, right? And so this facilitation, it has been discovered, comes also mainly from corporates. And the Malabo Protocol is introduced, the first supranational court to introduce corporate accountability for international crimes. And if we want to get rid of this kind of development in international criminal law, just because of this kind of clause, then we are losing the mark, because, you know, as much as we prosecute individuals, we still see new individuals coming on board being facilitated to commit these crimes. So if we can deal with the source, which are corporates, then slowly we can come down and say, okay, now let's look at this kind of amendment and adopt a much more progressive clause. And besides, Olive, you will agree with me, it is not very easy to prosecute a sitting head of state. I'm sure you have witnessed what happened in the Kenyan scenario. And because supranational courts are based mainly on cooperation by states. If a state does not cooperate, then you are likely just to lose the case. Yeah. And so going by this kind of precedent, we do not want just to have laws in vain. So we really need to sit down, rethink this clause, not just for purposes of agreeing or disagreeing with it, but for purposes of finding a meeting ground, which is the best way forward for this continent. Okay?
Okay. All right, let's take a look at what else have been identified as sticky issues. Here we go. Number 2, the issue of definition of crimes. I feel like I've skipped the question of capacity. Yes, here we go. Capacity. With a jurisdiction covering 3 areas of international law, it is questionable whether the new court, as envisioned under the Malabo Protocol, will have the capacity to effectively and efficiently deliver on its mandate. The proposed court will have jurisdiction over 14 crimes with the potential of new ones to be added. Only 3 core international crimes fall under the jurisdiction of the ICC, and for that the court is still at times vastly short on expertise, resources and capacity. Undoubtedly, some of the crimes have a particular resonance in Africa, like unconstitutional changes of government, and we'll get into more details on that, and illicit exploitation of natural resources. Still, the number of judges envisaged for the African Court of Justice and Human Rights is insufficient for it to operate efficiently with the jurisdiction to deal with only 3 crimes. The ICC has 18 judges, yet the proposed ACJHR will have only 6 judges dedicated to the international crime section, which will have a jurisdiction over 14 crimes. Speaking of the crimes, especially the crimes of terrorism and unconstitutional change of government, there is a concern that has been raised, definition of crimes. So this is the 3rd sticky issue. There are concerns about the implication of vague, broadly defined crimes in the ACJHR statute, and in particular with respect to the crimes of terrorism and unconstitutional change of government, which may therefore be used to clamp down on the legitimate exercise of freedom of expression, association, assembly, and human rights. The broad formulation of the crimes as currently drafted raise serious concerns as to the compliance with the principle of legality established under international law. Definition of unconstitutional change of government in the Malabo Protocol may potentially criminalize popular protests. And here, definition of terrorism in the Malabo Protocol, they say, is overly broad. With regard to terrorism, it is defined in the Act as a violation of the criminal laws of a state party, the laws of the African Union or a regional economic community recognized by the African Union or international law, which may endanger the life, physical integrity or freedom, or cause serious injury or death to any person, any number of group of persons, or cause or may cause damage to public or private property, natural resources, I was about to say natural resources or cultural heritage, and is calculated or intended to 1, intimidate, put fear, force, coerce, or induce any government, body, institution, the general public, or any segment thereof to do or abstain from doing any act, or to adopt or abandon a particular standpoint, or to act according to certain principles, or to disrupt any public service, the delivery of any essential service to the public, or to create a public emergency, or 3, create general insurrection in a state. And sounds familiar? Is it setting off any light bulbs? The crime of unconstitutional change of government for the purposes of the statute, unconstitutional change of government means committing or ordering to be committed the following acts with the aim of illegally accessing or maintaining power. A coup d'etat against a democratic elected government, an intervention by mercenaries to replace the democratically elected government, any replacement of a democratically elected government by the use of armed dissidents or rebels, or through political assassination, any refusal by an incumbent government to relinquish power to the winning party or candidate after free, fair, and regular elections, any amendment or revision of the constitution or legal instruments which is infringement on the principles of democratic change of government or is inconsistent with the constitution, any substantial modification to the electoral laws in the last 6 months before the elections without the consent of the majority of the political actors. And for the purposes of this statute, democratically elected government has the same meaning as contained in AU instruments. So after reading this, from a layman perspective, these Azimio protests, would they not count as acts of terrorism? Annette?
Of course, definitely. They really qualify, you know, to be in that category. So for me, the definitions are quite disturbing, and we would say the devil is actually in the details. The intent of the instrument, for me, is good because it aims at ensuring peace, security, and stability of the continent. But again, we should not overlook the process. In this case, when you talk about a democratically elected government, for me, it's relative. With the rise of technology, I mean, in the continent, we have seen chaos and cases where governments are struggling to prove that we have democratically elected governments in the continent. So there are contentious issues of which we've seen opposition governments and also military actually take otherwise unconstitutional action to be able to find themselves in power. Perhaps that's the definition of justice. Because again, when you talk about democracy, it's quite relative. Yeah. Also, as we see the mandamanos happening, it's, for example, in the Kenyan context, it's freedom of expression, you know. We have that right to picketing under Article 37 of the Constitution. But again, looking at these definitions, it's quite vague. And the question would then be, what does it take to be able to deduce that certain acts are or perhaps qualify to be able to fall in the category of crimes. So it's as she had said, at some point it would be important that conversations are held to be able to just have consensus on some of this definition, and if need be, we see amendments to the same, because what we are likely to see are violations of rights of very many Kenyans and also Africans on the continent, because we have instruments that, again, really do not serve the interests of the Africans and also perhaps in the Kenyan context of Kenyans.
All right, so we get into more detail. We'll get your perspective on it. Dr. We have in studio Dr. Evelyn Asala, Lecturer, Faculty of Law, University of Nairobi, and Annette Nerima, Program Manager, Kenya Human Rights Commission. And we'll come back and I'll get Dr. Asala's perspective on those definitions. Do they set up red flags for you on the other side of this break?
Benefits of ordering with Glovo. Glovo allows you to order anything you want at the comfort and convenience of your home. Craving fried chicken or pilau or pizza? Easy and simple. Order on Glovo today. Glovo, order anything, we deliver in minutes. With Glovo, you order anything unataka, and when you get it, una celebrate because kukuchoma imefika, na wakati keki inafika ndio sherehe inaanza. Order Glovo, will deliver in minutes.
But I know that meat looks tender, but maybe not so much when your chest is burning. Remember what happened the last time? Hey, dude, you don't listen, man. Are you testing yourself? I tried looking out for you, bro. Hey, you see now? How's the heart burn? Look now, it's burning.
Do not hold back in any situation. Eno gets to work on the 6 symptoms of heartburn fast.
You do know you said all of that out loud, right?
If symptoms persist, seek medical advice.
Daring Abroad makes me dare. It's the only show of its kind in the world. And now, it's bigger.
And even more entertaining and informative than before.
Hapa kunaitwa Kakoe na inatubaba sana.
From London to Jersey Island.
Goma in the Democratic Republic of Congo to the scenic features of Uganda, the Pearl of Africa.
And many more places abroad and at home.
I watch Daring Abroad. I like the stories which people bring.
Daring Abroad every Saturday at 7:30 p.m. with repeats every Sunday at 1:30 p.m. on NTV.
Sitapungukiwa, ujasiri ninao, yeye ni ngao, akiwa nahodha kwenye chombo ni salama, ameahidi ataniongoza nyakati zote, nikiwa na yeye Mwokozi mimi ni salama.
To get Bwana ni Mchungaji, dial *812*800#.
Skiza na Nation.
Thank you for staying with us on AM Live, and with me in studio I have Dr. Evelyn Asala, Lecturer, Faculty of Law, University of Nairobi, and Annette Nerima, Program Manager, Kenya Human Rights Commission. Dr. Asala, there was a question of definitions of some of these crimes. Two in particular have been red flagged in this report by Amnesty International, including terrorism, definition of terrorism, and here we go. The other one is unconstitutional change, the crime of unconstitutional change of government. Did this raise any red flags for you?
Yes, Olive, but it's just interesting that number one, you only flag out 2 crimes out of 14, meaning that the other 12 have very positive and progressive definition. And actually, I wish we began by looking at the contribution of the Malabo Protocol on defining crimes, because it makes substantive and contextual contributions on defining these crimes. I think I do agree with the criticism on terrorism and unconstitutional change of government. And for me, with respect to generally the transnational crimes, unlike the international crimes, we find a situation where we do not have the threshold of measuring which crime qualifies to be prosecuted by the Malabo court and not any other. So for instance, while the international crimes have internal qualifications of establishing the threshold, for example, crimes against humanity, there should be widespread, systematic, targeting A, B, C, D. With the transnational crimes generally, including terrorism and unconstitutional change of government, we do not have that kind of measure. And considering that we are talking of a supranational court, which only exercises jurisdiction for those who bear the highest responsibility, it is essential that we do have a necessary amendment, because these are issues that really can be fixed by amending them. Yeah, they are not cast on stone, so we can amend them to have them create either a general kind of criteria of determining what actions should achieve what kind of threshold for them to be prosecuted by this court, and not just any kind of unconstitutional change of government or any kind of terrorist act. So I think these are issues that can be dealt with through amendments.
Okay.
Yeah.
And I'm curious, what does the protocol provide in terms of what triggers the African Court of African Court of Justice and Human Rights? Yeah, is it the member state which invites the court to come in? Is it, like, how is it triggered?
Yeah, I think the protocol provides more or less similar provisions to the Rome Statute. So we have member states to the AU who can trigger the court's jurisdiction. We also have the Peace and Security Council of the AU, which is more or less something similar to the UN Security Council, but within the African continent, which can also trigger the jurisdiction of the court. And also we have the prosecutor exercising their own promoter powers or discretion to bring cases before the court. So it's more or less similar to that of the ICC.
Okay.
Yeah.
So, and what do you make of the question on capacity? Because the argument is that the ICC deals with 3 core international crimes, has 18 judges, and the proposal where this is concerned is 14 judges for 14 international crimes.
Yeah, yeah. I think that is likely to be a challenge, but again, it is not insurmountable. Given the fact that, number one, we are only talking of those who bear the highest responsibility. So we are not talking of everyone who commits terrorism, everyone who commits unconstitutional change of government, but specific individuals that we want to be targeted by this court. And also, we are hoping that, the existence of the court will be deterrent by itself, so that, at the end of the day, we really want to rid the continent of impunity and not congest the court with cases over and over. Okay.
So actually, let me see how many, it's 14 crimes and how many judges?
6.
6. Yeah, so I do beg your pardon. ICC has 6, 18 judges, yet the proposed ACJHR will have only 6 judges, and the proposal is 14 crimes. I'm guessing, okay. Let us take a look at what else is at issue, and there is the question of, here we go, impact on human rights jurisdiction of the court. The Malabo Protocol may have a deleterious effect on the human rights jurisdiction of the court, including possibly negative new implications on future ratifications of the statute of the current African Court on Human and People's Rights. Malabo Protocol envisages the reduction of judges responsible for human rights issues from 11 to 5 for the existing African Court. Such reduction will significantly impact on the capacity of the court to expeditiously hear human rights cases. The backlog of the African Court is growing, as at the end of June 2016, the court had received 101 cases, of which only 27 were finalized and 4 transferred to the African Commission. Let us take a look at what else, the other concerns they've raised, because these are capacity challenges still. The question of funding. It is unclear whether the AU will have the requisite resources to operationalize and sustain the ACJHR. The EU struggles to adequately finance its own operations, including its human rights treaty bodies. It funds less than 25% of its budget, excluding peace and security budget, which is funded almost 100% by donors. Yet the AU continues to establish more institutions. Some donors who have traditionally financed the AU, e.g. the EU, have already indicated that they would not finance the ACJHR on account of the immunity clause. Some figures presented here on the document. And so before we get into competing obligations, especially the ramifications on the Rome Statute of having such a court for those who are signatories already, the issue, how critical are adequate resources to justice? Is this a concern? Would this be a concern?
Yes, it is definitely a concern because, again, it would impact on the timeliness in the prosecution of these cases. You've just talked about the statistics. Out of the 101 cases, only 27. So the question would then, in a span of what time? We all know justice delayed is justice denied, and that's basically the scenario that is being painted here, and which is also a worrying trend. And we are talking about funding. We have 33 African states that have ratified to the Rome Statute. Yes, to the Rome Statute, sorry. And also, again, about or over 15, also again, to this, the African Court of Justice and Human Rights, again, to support the same. So these are just individuals, again, not individuals, but rather countries that, again, are ratified the other side on the Rome Statute and also here on the African continent. In terms of supporting and funding, it becomes very difficult to see these nations, again, split or have adequate resources to be able to sustain the two. That is quite an issue. And of course, when you talk about capacities, they also point to the resources because, again, there's no way the judges will be kept afloat if we have inadequate funding. Yeah, and I gave a good example. When you talk about funding of the same, when we see heads, when we see governments not able to support or be able to fulfill the obligations and the pledges that they gave to support a case, for example, like that one of the former president of Chad, when he was being prosecuted in Senegal. What does that tell you? That it's this funding aspect can either enable or be an impediment to access to justice for citizens on the continent, because, again, the heads of state can either decide to support or not to support. What that then does, it cripples the mandate of the mandate and also the functioning of the court on the African continent. So that is quite a contentious issue. And again, as they say, who pays the piper calls the tune. Development partners have been the ones supporting and keeping afloat this court, but if they threaten to pull out, what becomes of it? Are we gonna, we are likely then to see stalling of cases, and definitely that means justice has been denied to many citizens on the African continent who would want to see. I think it would also be important to note that when you talk about the capacities and the numbers, 14 kinds of cases vis-a-vis 6 judges, that's quite a concern, because looking at the African continent right now, there's evolving of very many crimes. When you talk about corruption, what are the numbers? How much is being lost? And particularly the culprits are the heads of state, you know, and the senior or the topmost public officials, you know. At the same time, we're seeing the rising debt burden again. That is also basically misguided and, or rather, decisions that really are unconstitutional. We are seeing a lot of things in terms of money laundering today on this continent. So there's rising numbers in terms of crimes, the 14 crimes. So chances are high, most of these senior government officials and also the heads of state, once they leave power, most of them are likely to be charged. And I think with this rising authoritarian governments, right now we know when you talk about fully democratically states, there are very few. We are seeing the flawed democracies right now. We are seeing a hybrid of those. And as those ones continue to constitute our continent, what definitely means is that we have violations of human rights happening in many, in numbers. So this definitely means that the judges will be overwhelmed and the wheels of justice will then continue to roll slowly, and that really affects negatively the quest of access to justice.
All right. At the very start of this document, it says this was proposed as an African solution to African problems. And even on the poster, you know, we ask, is this a question of self-determination or self-immunity? But even if it were a question of self-determination, to quote, and let's hear, he who pays the piper calls the tune. Are we ready for this kind of court?
Yeah, that's an interesting question, Olive, because when you look at the funding part of it, it is very critical for any investigations, especially of the nature of crimes they want to deal with, and it requires a lot of funds. And one interesting thing is that when you look at most programs within the African Union, they are funded by outsiders. And so you want to ask yourself, is the AU ready to fund this court? Because most of African economies are already overly stretched. Are we ready to impose a certain tax to the court? Is it going to be feasible, or is it going just to bog down the objectives of the court? So I think these are very critical questions that must be considered at the very high level of the AU to see whether there are any innovative ways of making sure that the court is sustainable in the future, and not just creating a court for a certain period of time. And so I know within the peace and security architecture of the AU, there are some innovative elements of, trying to create a sustainable, internally funded kind of taxation imposing on states. But I don't know if this is sustainable as well, especially when we talk of the African court. Because again, the same way you talk of he who calls the piper, it is the same politics we have in the AU. So I don't know, because for the AU we have the senior states like South Africa, which funds heavily the Peace and Security Council. We have other countries that fund the Security Council. But again, you get this feeling or this perspective from other countries that, these individuals are favoring themselves, they are forming themselves into permanent 5 members of the PSC. So the same politics we have at the global level, it's really the same politics we have at the regional level, and it's not going to be different with the African court. So maybe it's just trying to see what is it that will work best for us? How do we bring these wheels of justice into operation, and not just get rid of the idea altogether?
All right. Annette, on the question of self-determination, when this came up, there was the view that, African countries targeted more than any other nations, and even the US, I don't believe, is a signatory to the ICC, So it was there's a view that these people from the outside, kwani wanatuona aje? And so this is how this was proposed. Even now, there's that clamor that at the UN Security Council level, Africa should have a permanent seat, at least 2, I think, was the last information I read somewhere. And even the clamor on access to to funding on at the international markets. Africa is constrained by prohibitive interest rates as compared to the developed world. So, and maybe, and in many cases, there was an instance, I think, that was given by, this is something even the UN Secretary General has spoken about. Riskier countries are given friendlier interest rates than countries on the continent. So there's again that clamor, that Pan-African-ness. That's again, it was the same way the former President Uhuru Kenyatta, even President William Ruto, we really see him out there even talking on the subject of climate change. And he's like, you need to stop looking at us as victims. We are part of the solution. So, don't you see this as part of that push that we will determine our own affairs?
Thanks. In an ideal setup, this is a brilliant idea because, again, it's homegrown solutions, solutions that are tailor-made to African problems. That's brilliant, and also being executed by individuals on the continent that basically understand what the challenges are. When you talk about these crimes, they know the patterns, they know the trend. Makes it very, very easy. The question is, are we ready? And are we even, what's the sustainability mechanism to the same? We are just talking about development partners supporting or keeping afloat the court. What does that say? Are the Africans ready in terms of resources, in terms of capacity to be able to keep this court afloat? So if at all we want a homegrown solution, for me it should be holistic. We cannot purport to say that we need the same, and that's what we are geared towards, yet no effort is being made, including funding, ensuring that we have adequate capacity to be able to execute these cases in a timely manner, and then we purport to say that the homegrown solution. It's a good one because it also introduces the transnational crimes, you know, which again, when you look at the African context, on the African context, these are actually the kinds of crimes that prevail, the kinds of crimes that we see from on a day-to-day basis on the continent. So it's really a good idea, but for me the devil is in the details, and also my concern would be, are we even ready? And being ready means we are answering the question of sustainability. We are ensuring that we take a holistic approach, including the structures and the architect of the court, being that one that is enabling, you know, the intended goal. Yeah, that would work. But I see, I would say at this particular moment, we still have very many questions to ask, to ask, and also to be answered, and also would quite be concerned that as heads of state, in my view, I would say that is basically double standards. You know, on this other side, you act like we want to be on our own, yet we are here being, seeing corruption rising, you know. It's us, it's a man-eat-man society where we are the very people who are really depriving of our people of basic services, of violating their human rights. Then at the end of the day, we say we want our own. So I would say we are not ready. We are not ready as a continent.
All right. Yeah. The elephant in the room, what does this then mean for nations such as ourselves, already party to the Rome Statute? What would it then mean? Competing obligations. African Union members that are also state parties to the Rome Statute are likely to face several challenges. The Rome Statute, the treaty that established the ICC, has been ratified by 34 AU member states. These states will have obligations both to the ICC and the ACJHR. It is not clear how these competing obligations will be addressed by the Malabo Protocol. In the event that the ACJHR and the ICC indict the same person and order his or her surrender, a state party to both the Rome Statute and the Malabo Protocol may have to choose which obligation to fulfill and which one to breach. The same dilemma may also arise in relation to competing cooperation requests. The Malabo Protocol provides for the ACJHR to seek cooperation or assistance of regional or international courts. But if the existing tension between the AU and the ICC continues way into the existence of the ACJHR, then the likelihood of ACJHR cooperating with the ICC will be rather slim. Moreover, both the Rome Statute and Malabo Protocol require domestic implementing legislation, but the two treaties have a number of differences, like the definition of crimes, which will pose another challenge to state parties to both instruments. What do you make of this, Daktari?
Okay, thank you.
Because you had taken the view that one doesn't negate the other.
Yes. And so just to emphasize on my previous view and standpoint, that, you know, these are two supranational tribunals. They have both been created by heads of states or member states who come together to negotiate treaties. And you notice in international law, we do not have a hierarchy of tribunals. Every tribunal within the global or international law is independent, and it is self-contained, I would call. So they have self-contained jurisdiction. So while the ICC exercises its jurisdiction over its mandate, the African Court will equally exercise jurisdiction over its mandate. And we cannot say that the African Court is going to be subservient or it's complementary to the ICC. No. These two courts, we can say it is horizontal to the ICC in the sense that they occupy the same space in international law. And so one is not below the other, neither is one an appellate court to the other. So the two are completely independent, and the two will exercise their mandate with respect to international crimes. Now you talk of a situation where both courts are indicting the same person. I think this is a situation that is unlikely to arise because, you know, in the sense that the African court takes up a case, then on what basis will the ICC be taking up the case? Yeah. So for me, it just depends on who. Perhaps what we can talk of at that point is the two institutions can sit together and agree on modalities of cooperation, yeah, where such a scenario arises. But I don't foresee that kind of thing arising, because once one court takes up a matter, then automatically the other court is out, unless in a situation where now the Malabo Protocol exercises immunity, yeah, brings in force the immunity clause and says we will not exercise jurisdiction over this person because they enjoy immunity under Article 46A. Then in that situation, the ICC will be happy to prosecute this kind of a person. Yeah, and so when we look at the African Court and the ICC, let's look at them as equals, yeah, and not one being subservient to the other, and having independent jurisdiction from each other.
Okay, just before I come to you, Annette, just a follow-up. What would a withdrawal from the ICC involve? If I say I want to subscribe to the African Court of Justice and Human Rights?
You know, in criminal law, it is not the accused person who chooses where they should be prosecuted. Ideally, it is the prosecution office, the office of the prosecutor, that will indict, the office of the prosecutor that will determine, you know, where you're being prosecuted. So it is not for you to say, oh, I want to choose the forum you want to be prosecuted. No, it is not. It does not work like the national courts where you say, I want my case to be prosecuted in Kiambu because I stay in Kiambu. But this is an international level where we are talking of prosecutions being determined by several other factors other than just where you reside or other cost implications.
All right.
Yeah.
And I'll come back to you on the withdrawal from the ICC, what that process is like. Annette?
Yes, I think importantly, as she has mentioned, my colleague has mentioned, these two courts are actually standalones. They have exclusive powers to prosecute, you know. And important to note is that the complementarity aspect is actually missing. These two it's actually missing amongst these two, the ICC and the African Court. Yeah, so there's nowhere where it states that perhaps the two can work closely together on matters, cases, and how to do the same. So they are standalone, they are independent in their own ways. And so that poses a challenge and also a concern, even as we continue to see them come into being, on how perhaps they would want to work together to ensure that we, at the end of the day, have ensure that justice is realized. And also, again, there are also differences, which, and I think when you talk about the complementarity aspect and we talk about the differences, that alone raises red flags as to the existence, especially of the AU court. For example, the ICC actually does not have that issue of impunity. Immunity, sorry. It does not pronounce itself to the same. But here we have the African Court, which again provides for that. Perhaps that is what would be interesting many heads of states or AU members to be able to come to this other side. Yeah, there is the issue of ensuring that the regional treaties are put into consideration, and also the national frameworks of the EU member states as to when the cases are being taken up. But there is the difference of the immunity, and also the same missing in the ICC perhaps could be the reason as to why we see people or the governments being swayed to come to this other side. So in a nutshell, what I'm trying to say is that there are differences, there are gray areas, there are concerns that perhaps without clarity, it would be very difficult to say that the setup currently as is we could say the setup as is problematic, and therefore this needs to be addressed before we can say we are ready to kick off.
Okay. So two questions, Daktari, in quick succession. One, there's a question of if now African countries decide, and that was what triggered this process to begin with, that we will not be subject any longer to a beberu, to the white man. What would it involve to withdraw from the jurisdiction? or to remove yourself from the jurisdiction of the International Criminal Court. And number two, I was reading, I think it was a Star article which made a reference to the Malabo Protocol Act. And if it is indeed already an act, I would imagine it has already been passed into law, although maybe not in specific countries quite yet. Is there room then to amend some of these issues that have been raised?
Okay, maybe before we get into the two questions, I would like to just elaborate something on complementarity. When you talk of complementarity, one court being complementary to the other, it means you're complementing me, you're helping me do my role, and if you fail, I take it over. So we cannot use the term complementarity in its strict sense in the relationship between the ICC and the African Court, because these are completely independent courts. And if we want to say the African Court is complementary to the ICC, it means we have a vertical kind of relationship where we can appeal from the African Court to the ICC, which is not the situation here. We are talking of two courts that are independent and that can exercise their mandate independent of each other, irrespective of what decisions have been made before in one court or the other. So it is important that we get to know the fact that complementarity in its strict sense cannot be used within the relationship of the two courts. Now, on your question, what was your question again?
Room for amendment and withdrawal.
Yes, you talked of the Malabo Protocol being already an act.
It's an article. I read the article and it referred to it as the Malabo Protocol Act.
Okay, maybe that meant it is a statute of some sort, but within the context of international law, the Malabo Protocol has not come into force. It has not received any ratification so far, while it requires 15 ratifications to bring it into force.
Is there room to amend?
And so we still have a lot of room to rework on these articles, to engage the AU and see how to amend all these controversial provisions.
Even after these countries have already signed on, you talked about 15 thereabouts?
Yes. Yes, even after signing on, we can still amend. Even after ratification, you can amend a treaty at any time, but if it is after ratification, then those countries that have already ratified need to ratify the amendment again.
Okay.
So there is no time limit within which to amend a treaty.
That would happen at what level? The head of state level? Or?
Yes.
Okay.
The Assembly of Heads of State.
Okay.
Yeah.
And finally, if African countries who are party to the Rome Statute now say, we are now not willing to be under that jurisdiction, sisi tuweke kwa Africa Court of Justice.
Yeah, I know such discussions have been there, especially in 2014, where we saw threats of en masse withdrawal from the Rome Statute, and the statute provides for, a withdrawal process. If any treaty does not, then we go to the Vienna Convention, which is a customary international law treaty that provides for the process of how a state can withdraw. Basically, where you deposited the ratification document, you simply just deposit your notice to withdraw. Then you have to wait for a certain period of time. I think it is 30 days within which that withdrawal notice now comes into effect, and you'll be deemed to have withdrawn. So there is no statute to which we are bound permanently. The same way you have consent to get into a statute, it's the same way you have consent to withdraw. You can consent to withdraw.
Would that require the involvement of the National Assembly, the people's participation?
Ideally, ideally it should, because when you look at our constitution, it is people-centered, and any decision by a government that has an impact on the people, then the people must be involved. And so there is no decision of public interest that the government should get into without involving the people of Kenya.
All right. Yeah. I want to thank my panelists this morning and make way for your world. But this morning on AM Live, we've had in studio Dr. Evelyn Asala, lecturer, Faculty of Law, University of Nairobi, and Net Nerima, Program Manager, Kenya Human Rights Commission. And this is what we were interrogating. We were re-examining the African Court of Justice, the fight for human rights and the quest for self-determination. Or was it self-immunity? Thank you so much for joining us. My name is Olive Burrows. Winnie Lubembe coming up next with Your World.
to The Morning Fix. This is the show where we do ukarabati wa asubuhi. My name is Mariam Bashar.
And the most bankable host, Brian Aseli. Good morning, my neighbors!
Get up and get ready for the most electrifying morning show on your airwaves. Mariam and Aseli on The Morning Fix every weekday from 6 to 10 a.m.
I think Uganda is the only country that they can actually do a musical. All of them. Because they speak funny.
No.
They speak funny.
Only
on 96.3 Nation FM.
All that talk about the best.
I see you trying to be an OG like me, chasing dreams, pulling more schemes for wealth. But the best thing is
seems nice and bright and everything feels alright. I went to school without a fool, trying to pick a fight. I was loped out, crisp pro shirts. Now I feel you know you got to have them.
For the best of the 2000s, tune in every Saturday from 10 a.m. to 2 p.m. and Sunday from 8 p.m. to 12 midnight.
So live your life.
Rhythm and flow.
Taking you back in the day.
Nation FM.
Mosacha hizo.
Nani nani?
Unajua deal na mimi.
You're treading on dangerous ground.
Nakuuliza unawajua? Kevo bana, pole pole, jo ni dem. Udem anajua kitu.
Mzee mlango ndio hii.
Mbeni kilo 2.
Ni jina na gani?
Oya TJ. Mabubu fire huku nje tuende.
Is this where you're throwing money down the drain?
How? On this cleaning product?
Impossible! Harpic 10X. While other cleaners flow away, Harpic 10X's viscous formula in only one round of application gives you sparkling, clean toilet.
Harpic, 10 times better cleaning than other cleaning products.
And great savings too.
What's up? I'm having lunch with Alberto. I just excused myself from the table.
Yes, I can meet you right now at Caprico.
I'll see you there.
That is the gown that is being made for Natalia.
I was just showing it to Diego.
And why do you have to wear it and show it to Diego, acting as if you are his own personal model?
Mother, what are you hinting at?
No, I'm not hinting at anything.
And keep your distance. This is a very delicate situation and it's only Alonso's business.
But darling, I was just...
But nothing. I'm going to say it again. Do not say anything.
Head over heels.
Ndio hiyo. Na ndio hapa basi nimekuja nikufahamishe na nikuambie live and direct. Usiwahi amini binadamu. Mwanzo waliokuambia hapa basi bila shaka pale uwachague maisha itakuwa rahisi. Ndio hiyo maisha imekuwa ngumu zaidi. Waliokuambia hapa basi bila shaka pale usile na usikunywe ujifunge kama una Yesu na macho. Basi ndio huyo wewe umekauka umekufa. Ai, mwishowe kaenda jehanamu. Waliokuambia hapa basi watumie fea. Wameshaikula na hawakukuja. Waliokuambia hapa basi bila shaka pale
To get stories ajaba, dial star 811 star 851 hash.
Skiza, non-nation. The world unites as the FIFA Women's World Cup comes alive on your screens. Feel the adrenaline. Embrace the passion. And support your favorite teams in their quest for glory. From the thrill of the group stages to the intensity of the knockout rounds, every moment counts. Join us on NTV as we bring you every exhilarating match, every kick, every save, and every single victory.
And it's a spectacular goal!
The FIFA Women's World Cup, exclusively on NTV, your front row seat to greatness.
Ukivaa suti usiongee sana. Kuongea wachia watu wa t-shirt. Ukivaa suti una smile tu. Ukivaa suti usigote. Kugota wachia watu wa t-shirt. Wewe fanya handshake. Bora umevaa suti. Ukivaa suti wewe tulia tu. Wacha suti.
To get suti, dial star 811 star 926 hash.
Skiza, non-nation.
1, 2, 3, 4.
Tune in to NTV every weekend at 9 a.m. for Kids Adventures, the ultimate cartoon extravaganza. Don't miss the laughter, fun, and magic.
Selfish, 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 selfish.
And it's not just about entertainment, it's also about teaching valuable life lessons.
Let's practice sneezing into your elbow. Achoo! Yay! You did it!
I'm going to show you how to decorate a bottle using glitters.
Let's go.
Reach your audience instantly and make a lasting impression with Nation Sema. Affordable SMS at 0.3 Kenya shillings. Own sender ID for 10,000 Kenya shillings plus 10,000 free SMS. To sign up, please call 0790 111 111 or email us on nationsema@ke.nationmedia.com.
It's the headquarters of good vibes. So I should just kneel and begin to call on Jesus because I'm a bishop. So what are we
You know, Dr. Kingori? Yes. You sound like a street fighter. Where did you grab it? Unataka noma.
Kingori, let me tell you something. Mimi mtu angenipata saa hiyo nikiwa first year. Angeangukia bibi mzuri.
You know, they always say smart women, where to catch them is with love.
Kingori, I love how your suit looks. I love you in a suit. I love you in a t-shirt.
As in any example, you actually mean that.